Good morning and welcome to the Senate Committee on Commerce and Labor for the 81st legislative session. Before we begin, please be sure to mute your microphone when you are not speaking to minimize the background noise. Madam Secretary, please call the roll.
Senator Hardy,
Here.
Senator Lang, Senator Lang, Senator Neal,
Here.
Senator Pickard,
Here.
Senator Scheibel,
Here.
Senator Settlemeyer,
Here.
and Chair Spearman.
Here. I thought I saw Senator Lang, but please remember to mark her present once she arrives. Okay? Thank you. So welcome to our audience joining us remotely and anyone listening over the internet. Today, we have a hearing on Senate Bill 100. I would like to take a moment to go over some basic housekeeping items. As you know, the legislative building is currently closed as a public safety measure to reduce the spread and infection rate of COVID-19 to the public. And so all committee meetings will be held virtually, meaning committee members, staff, and everyone else will participate either through Zoom, video conference, or by telephone. However, there are various ways members of the public can engage with us and participate throughout the process. These include registering to participate through Nellis, where you have the opportunity to testify on a bill or provide public comment during the meeting, or submitting written comment to the committee email and address or fax number listed on the agenda. You may also share your opinion via the legislature's opinion application on Nellis, or view committee meetings online through Nellis or on the legislature's YouTube channel. To register on Nellis, simply click the participate button near the committee meeting date and time. Then fill the required information in, such as your name, the agenda item you're interested in, and your position on the bill. Once your registration is submitted, you will see confirmation screen. And then you will receive an email with a telephone number and meeting ID to call at the time of the meeting. Just a note, while the meeting registration is required to participate, it does not guarantee you will be able to speak. Similar to previous sessions, comment and public comment may be limited due to time constraints. And I will announce the time frame, how many minutes for each response, for, against, or neutral. It will be helpful if more than one person in an organization or those who are listening wish to comment to remember that ditto is a good response when someone has already covered your points. This will allow for more people to comment during that time. When you're on the phone lines, please pay attention to which bill is being considered and follow the verbal prompts provided by the BPS staff so that you will know which keys to press to raise your hand or unmute yourself. Staff will call on you to speak by the last 3 digits of your phone number. Detailed instructions for participating in committee meetings are available on the help page, which is linked in the banner at the top of every page on Nellis. If you need assistance with any of these processes, or if you would like to receive electronic notification of the committee's agendas and minutes, please contact your committee staff at the email listed on the agenda. Any exhibits for the committee must be submitted by electronic format no later than 8:00 a.m. the day before the meeting. They must be submitted to our committee staff. Contact information may be found on the committee page in Nellis. In addition, any person proposing an amendment to a bill being heard by this committee must first talk to the sponsor and let them know you intend to submit an amendment. I will not entertain any amendments if the bill sponsor is not aware of the amendment. The proposed amendment must be submitted in writing 24 hours prior to the meeting. Please include the bill number, a statement of intent, and your contact information. When testifying, please remember to unmute your microphone and clearly state your name and the entity you represent at the beginning of your testimony. Speak clearly and project your voice. Remember, we have those who are listening over the internet, and if you do not project your voice, they may not be able to hear. Remember to turn your microphone off when you finish speaking. A reminder to all those who testify pursuant to Nevada Revised Statutes 218E.085, it is unlawful for a person to knowingly misrepresent facts when testifying before a legislative committee. A person who knowingly does so is guilty of a misdemeanor. The chair and members may request any testifier to submit documentation supporting their testimony. To committee members, during these virtual meetings, when an agenda item is called for a vote, our committee will be using the roll call to do so. When the committee secretary calls your name, please answer with a yes or no so that there is no confusion. Also, if you have a question, please raise your hand through the Zoom application. And finally, all exhibits received prior to the meeting will be available on Nellis online. And so now, we will introduce BDR 54-386, which provides provisions relating to sign language interpreting and real-time captioning. This is a committee BDR sponsored on behalf of the Legislative Committee on Senior Citizens, Veterans, and Adults with Special Needs. Remember, if you vote in favor of introducing the BDR, that does not imply a commitment to support the measure later. All this action does is to allow the BDR to become a bill or resolution and be referred to a committee for possible hearings. So now, I will accept a motion to introduce BDR 54-386.
So moved.
Motion.
So moved.
I think I have a motion by, is that Senator Hardy?
True.
Who made, yeah, Senator Hardy, did you make the motion?
Yes, thank you, Madam Chair.
Okay. Okay, motion made by Senator Hardy, and I heard a second. Was that Senator Settlemyer?
Yes, Madam Chair.
Okay, so I have a motion by Senator Hardy, second by Senator Settlemyer. Any discussion? Madam Secretary, please conduct a roll call vote.
Senator Hardy,
Yes.
Senator Lang,
Yes.
Senator Neal,
Yes.
Senator Pickard,
Yes.
Senator Scheibel,
Yes.
Senator Settlemyer,
Yes.
Chair Spearman.
Yes. And it appears that we have a unanimous vote on yes, and so the motion carries. So at this time, I will open a hearing on Senate Bill 100. The joint presenters are Senator Severs-Gansert, Nina Laxalt with the PT Board lobbyist, Charles E. Harvey, Executive Director of the PT Board, Jennifer Nash, Vice Chair of the PT Board, TJ Cantwell, Compact Administrator, Kelly Mae Douglas, Pacific Southwest Regional Liaison, DOD, State Liaison Office. And so, Senator Severs-Gansert, please begin when you are ready.
Thank you, Madam Chair and members of the committee. For the record, my name is Heidi Severs-Gansert. I'm the state senator from District 15 in Northern Nevada, and I'm here today to introduce the individuals who will be presenting Senate Bill 100. And the chair just went over the list of names, but we're going to start out with Nina Laxalt. So again, I want to thank you for your attention today.
It's me now, right? Madam Chair, members of the committee, for the record, my name is Nina Laxalt, representing the Nevada State Board of Physical Therapy. We want to greatly express our appreciation to Senator Severs-Gansert for sponsoring this bill for us. As well, I want to thank Terry Miller, the committee manager, because she was so helpful in guiding us through this system, which is sort of awkward and unusual for a lot of us just starting to learn how to use it. With me today, as you noted, I have Jennifer Nash, who is the vice chair of the PT board, and she will be discussing Nevada's situation as it pertains to PTs. Charles Harvey, who is the executive director of the PT board, and he will not be presenting, but will be available to answer any questions about the board itself and how this might impact the board. Kelly Mae Douglas, Pacific Southwest Regional Liaison, Defense State Liaison, and Kelly is going to talk to you about how the compacts impact the military and their moves and the families and what a benefit is for those members of our military. And then we have TJ Cantwell, and TJ is the compact administrator located in Virginia, and he is not going to present, but he is available to answer any questions about the nuts and bolts about the compact itself. Now, some of you who are returnees may remember that we brought this bill forward last session in the form of Senate Bill 186. It passed this committee and the Senate floor unanimously, but unfortunately, we hit a couple bubbles on the assembly side and weren't able to get it past the finish line. We are hoping to be able to answer any and all questions that come forward both in the Senate and in the Assembly, which will alleviate any concerns as to how this compact works and the benefits that it has to Nevada. I am also hoping that the committee members have found the time, which I know you have plenty of extra time, to read over the document that I submitted to you by email, which is also on Nellis, and it's the frequently asked questions document. That answers a lot of the basic questions you might have about the compact, this particular compact itself, and how they run and interact with the states and how states interact with each other, participating states. So the Physical Therapy License Compact is a state-based solution to the challenges of interstate portability for physical therapists and physical therapist assistants. It improves patient access to physical therapy service by giving eligible licensees in the participating states an easier and faster alternative to traditional licensure while retaining safeguards to protect the public. The PTLC, which is how it's referred to, provides substantial benefits for military spouses and families, making it easier for family members who are PTs to get licensed when they receive a transfer station. The PT Compact is an agreement between member states to improve access to physical therapy services and provide an expedited process to practice in another member state. The compact allows for a PT and a PTA assistant who is licensed in one member state to apply for a compact privilege to practice in another member state. 29 states have joined the compact. 21 are actively issuing privileges, and 8 are finalizing their procedures. The compact preserves a state's regulatory and disciplinary authority over a PT or PTA practicing in the state. The scope of practice is determined in the state where the patient receives care. PT and PTAs working in Nevada under this compact privilege must pass a Nevada PT Jurisprudence Exam in order to ensure understanding of Nevada rules and regulations. So unless you have any questions of me, I will turn it over to Jennifer Nash, the PT Board Vice Chair.
All right, hearing no questions. Greetings, Chair Spearman and members of the committee. My name is Dr. Jennifer Nash. I'm a physical therapist and the vice chair of the Nevada Physical Therapy Board, here to speak to you in support of SB 100. We believe the enactment of this interstate PT compact would benefit the underserved residents of Nevada, especially those in rural and frontier areas, where border states such as Oregon, Arizona, and Utah could assist in providing care to those areas, as well as our licensees who are military spouses, which are currently only 4% of our licensees. This compact would provide extra public protection because jurisdictions are able to then get critically needed additional physical therapy services for state residents when there is a state of emergency or local crisis. It is also an optimal way to form a compact. The PT compact privilege process is not a multi-state process compared to some compacts. Instead, it is an a la carte process, resulting in that the PT licensure board knows exactly who has a privilege to practice in Nevada. And the Compact Commission provides daily updates to our state licensing board. It also provides public safety. A person with any encumbrances or disciplinary actions against their license within the past 2 years cannot apply for the compact privilege. If this privilege is revoked in one member state, privileges to practice in other states are revoked also. Improving the access to service, this compact will allow the application for a privilege to be very efficient because it is a centralized reporting database. Therefore, it only takes 15 minutes to get a privilege compared to the 2 months for a traditional license application. And lastly, just to speak on the need, physical therapists and physical therapist assistants assist Nevadans to reduce pain and gain strength, flexibility, and balance to optimize their function and quality of life. In this great state, where many older adults retire, we are the 11th in the nation for rate of falls for older adults. And we are 45th or 50th, depending on the resource, dated January 2020, for the number of PTs per 100,000 population. Thereby, I support and hope that you as well would support SB 100, and I'm available for any questions.
Thank you, Dr. Nash. Is there anyone coming behind you before I open it up for questions?
Yes, I do believe we have one other presenter.
Okay. We'll hear that, and then after all the presenters, then we'll open it up for questions, okay?
Excellent. Thank you.
Thank you.
Senator, this is Nina Laxalt, and it will be Kelly Mae Douglas who will be speaking next. Thank you.
Thank you. Ms. Douglas, please proceed.
Thank you, Madam Chair and members of the committee. For the record, my name is Kelly Mae Douglas, and I'm with the Department of Defense State Liaison Office. Our office works with state policymakers to resolve the top quality of life issues facing military service members and their families. I cover the Pacific Southwest, so I'm focused on Nevada, in addition to California, Arizona, Hawaii, and Utah. Addressing issues, our licensure issues for our spouses has been a priority for the department for several years, and the new administration has committed to continuing this focus until we see widespread improvement. 68% of married service members have indicated that their spouse's ability to maintain their career impacts their decision to remain in the military or not. 77% of military spouses report they want or need to work. And military spouses are disproportionately affected by state-specific licensure requirements that cause delays and gaps in employment. We know that 24%, or the unemployment rate for military spouses was 24% before the pandemic. So we all understand that the pandemic has affected our communities as a whole, but just understanding that military spouses are disproportionately affected by anything that faces the general population. This is because we found that 34% of military spouses are in an occupation that requires licensure, and they also relocate across state lines at a rate 10 times greater than their civilian counterparts. Just as far as demographics, there's nearly 10,000 military spouses in Nevada. 5,400 are spouses of active duty members, and 4,500 are National Guard and Reserve spouses. The spouses of members in the Guard and Reserve and spouses of service members that are separating from the military generally are not covered under state-specific laws that are targeted to assist military spouses. Since compacts cover all practitioners within a profession, compacts such as the PTLC can support others within the military community seeking licensure as a physical therapist. In addition, the PTLC will support military spouses who are residents of Nevada and are transferred out to continue working in other compact states as a physical therapist when they leave. Just as far as the importance of compacts to the Department of Defense, DoD is supporting 8 compacts, including the PTLC this year, and more are coming in the future. The 2021 NDAA, the National Defense Authorization Act, provided funds for DoD to support additional compacts in the future years. In addition, the 2021 NDAA directed the military services to include specific metrics around quality of life in their basing decision models. Many federal grant programs also for the states are beginning to incorporate these metrics as a requirement for applicants. Licensing reciprocity is one of the required elements for basing decisions moving forward for the services. And each service branch is required to report back to the Secretary of Defense and Congress on their evaluation models that look at licensure. The Air Force has already conducted its first round and evaluated Nevada as yellow on a stoplight type evaluation, green, yellow, red. Yellow for licensure portability, and the same for physical therapy specifically. The Office of the Secretary of Defense also reported to Governor Sisolak in February that Nevada only partially met our criteria for supportive licensure portability policies. In summary, state policies that enhance existing licensure provisions for military spouses relieve one of the many stressors of frequent military moves by enabling spouses to more quickly transfer their license in order to obtain employment in a new state. These policies facilitate greater career sustainability for military spouses, improving their family's financial security and overall resilience. Compacts such as the PTLC are viewed as the long-term gold standard by DoD for providing true reciprocity and ability for military spouses to get to work in Nevada in all states without delay. And with that, I will close and open for any questions. Thank you.
Thank you. Senator Sievers-Gansert, is Ms. Douglas the last presenter?
Thank you. For the record, Heidi Sievers-Gansert. Yes, she's the last presenter, but we also had an amendment, and you should have that in your package. The compact is very sensitive to the language and it needs to match up. And so you'll find that you should have received that in your package as well. Thank you.
Yes, ma'am. Thank you. So I will now open it up to members of the committee for questions. And I see Vice Chair Neal.
Thank you, Senator Spearman. I have three questions, but they're coming from 2 sections. So on Article 4, I guess it's line 27 and then line 30. I guess I'm trying to get an understanding because it basically says that you can have no encumbrance on any state license. And then in line 30, it says, have not had any adverse action against any license. But what's not clear is that doesn't seem to mean that is just the physical therapy license. that these are other licenses that you may hold. So can you clarify that language before I go to my second question?
Madam Chair, Vice Chair Neal, I'm going to turn that, this is Nina Laxalt for the record, I'm going to turn that question over to TJ Cantwell, who is online, who is the compact administrator.
And for those answering questions, please go direct to the committee member.
Madam Chair, members of the committee, for the record, I'm TJ Cantwell. I'm the Physical Therapy Compact Commission Administrator. To the Vice Chair's question, when we're referring to any adverse action against any license, our main focus is related to physical therapy licenses. So in some cases, individuals may hold both a physical therapist and a physical therapist assistance license. And so that would refer to both of those licenses. We do not track any adverse actions or encumbrances that may be held against another license if they would hold it for a different profession.
Okay, thank you for that. And so my next question comes from section, I believe it's section 5. No, it's section 6. And I'm asking this question because at the end of the bill, right, you go into the commission, but this particular provision, the way I read it, affects the licensee specifically. So my questions are in sub 5, where it's talking about a remote state may take adverse action, issue a subpoena for hearings, et cetera, right? There seems to be an issue, or I'm trying to get an understanding on, number one, conflict of law, choice of law provisions, because there's a sentence in here in line 24 and 25 where it says the witnesses or the production of evidence from another party's state must be enforced in the latter state by any court of competent jurisdiction. So the first thing that popped in my mind was, this is a choice of law situation. Tort is determined by the place of the injury. And this just seems to be, the language is so broad that I'm not clear who has jurisdiction and where this could occur. If there's a contract issue, it's a place of the contract. But this seems to be that you can issue subpoenas. You can basically go into any state, drag somebody into any state. And I guess I'm not clear, because when I look at the commission's rights, it seems to be very specific as to what happens. And so can you address that before I get to, because I had a question on sub C in that same section. Seems to be some jurisdictional issues with the regular person who's a licensee and what they're going to be dealing with.
Madam Chair, members of the committee, again, TJ Cantwell of the PT Compact Commission. I'm happy to answer that question. So in terms of jurisdiction, when it comes to an individual, the same jurisdiction would apply as it would today with a licensee that would be practicing from out of state, that would be practicing on a license in the state of Nevada. Again, what this does is allow that state where where any complaint is brought for that individual, the PT or PTA, to be brought before and be have due process under the laws of the state where the incident occurred. Again, so it would be no different than if somebody today was practicing, say, in Utah, and they had a license to practice in Nevada. They came to Nevada. They worked under that license. Then something happened in Nevada, right, and it would allow the ability for the state of Nevada to be able to take action against that individual, even though they originally and again are licensed in Utah and have residence in Utah. So it provides the ability for the state to still have the same authority and jurisdiction and really responsibility to effect due process in that state. As far as conflicts of law, what a compact essentially is, it is a contract between the states, which is one of the reasons why we need to have such very specific language, and each state has passed the same language in order to join the compact in the first place. And so contract law takes over in that case. Again, where that state's jurisdiction, where they have a scope of practice and that patient's located, is what governs the scope of practice for the practitioner. However, when it comes to, again, something like that, where it allows for states to have joint investigation, it allows them to share information, again, if they have a similar reason to share that information, because there is a ongoing investigation going on and potentially some legal action that needs to be taken. It again allows and gives that state the authority to do that, which is adding to the public protections of individuals, and that is the goal. But really, in essence, it really does not differ from what would happen today underneath the law, where somebody was practicing in the state with a Nevada license, again, but may have a residence in a different state.
Okay, thank you for that. Madam Chair, I'm getting to my final. So on line 31, sub C, same section, I'm in section 6. This is where it says, if otherwise permitted by state law, recover from the licensee the cost of the investigation, disposition of cases, etc. But the recovery of costs would cross any state, and it seems to be that the licensee, the actual therapist, could incur significant cost. There's no cap to that cost, and so I was wondering, why? Because because the first thing I thought was, okay, so under the compact, are physical therapists considered independent contractors? Is there an issue where we should have vicarious liability because they are with an employer? Or is it just all on the physical therapist to come up with potentially thousands of dollars because of an investigation? Because you have in this language that it could even be an alleged violation. It doesn't even have to be fully vetted. It could be, I believe that these things occur, and then the licensee is then paying.
Madam Chair, members of the committee, again, from the Physical Therapy Compact Commission perspective, so the answer to your question is that language is intended and I believe actually reflects much of the similar language that is in existing law, allowing for the boards to seek if allowed by law, by state law, to seek the financial remedy if they have been judged to be able to do so by a court. And again, so it is related to the same law. I think Ms. Nash may be able to better explain regarding the specific liabilities that PTs or PTAs themselves are subject to today under law, again, outside of the compact. But as far as I'm aware, the compact law and the language in our bill reflects, again, similar law that's on the book today, allowing state boards and other agencies to collect, again, if allowed and judged to be able to do so, to collect some kind of remedy after a judicial proceeding has taken place. So, but I defer to Ms. Nash regarding, specifically maybe in Nevada, what the liabilities are for PT or PTA under existing the licensure system there.
Ms. Knapp.
Sorry, hello. Jennifer Nash for the record. Thank you, TJ. So regarding to the specific liabilities that the PT has in Nevada, I don't have a dollar value that I could cite for you. It might be within our regulations that possibly Director Harvey could mention, but I don't have a specific number.
Good morning, Director Harvey. For the record, I am unfamiliar with any dollars that are cited in our statutes or regulations pertaining to this question.
So, Director Harvey, are PTs under the compact considered independent contractors where it would just fall on them, or would these fees be shared through an employer relationship and then vicarious liability kicks in? What happens?
Vice Chair Neal, I would need to refer that question back to Mr. Cantwell. I apologize.
Vice Chair, member of the committee, again, I guess I can't answer your question specifically to say what exactly would happen in a case where there would be a legal proceeding regarding that. Again, it's based on really existing laws that allow for states to be able to collect any fees back from the thing. And I believe it is same as your existing, whatever existing procedure would happen in their state. Again, I believe it says under which was allowed within your state law. So if there was something to be occurred in the state of Nevada, and your laws would supersede to allow, to determine whether or not that could be allowed and who would be liable for those fees. If that was determined to be allowed by the state of Nevada. Again, so it is meant to be broad in the sense of the state's laws would be the ones that would govern that, depending on where the action was taken and where the legal proceedings happen.
So thank you for that. I mean, because I get Nevada law, but that's why we try to refine the compact that so we're clear what happens in our state, right? And so thank you, Madam Chair, for the indulgence.
Thank you, Vice Chair.
Madam Chair.
Yes.
For the record, Heidi Sievers-Gansert. So what I heard from Mr. Cantwell was that the compact defers to the state. And so maybe Mr. Harvey or Jennifer could go over what would happen if it was a regular state licensee, because I think that's what we're saying is it's the same policy for someone who's actually licensed in the state as someone who has a privilege based on the compact in the state. Thank you.
Thank you, Senator Gansert. And this is Jennifer Nash for the record. And I do agree, once Vice Chair Neal rephrased, I understood better where she was coming from, and would agree that the compact privilege would be, that person would have the same liabilities as myself as a resident holding a regular license in Nevada. So in the profession of physical therapy, sometimes your employer does give some liability coverage to you. In other cases, you are in charge of holding that on for yourself. And I think it would be no different for a compact privilege holder. Thank you.
And we want to refer this also to our legal counsel so we can get an answer. It will probably not be before this hearing ends, but I'll make sure that we get it and everyone is aware as to where to find this. So appreciate the responses, and Vice Chair Neal, we're going to make sure that legal can answer the question too in accordance with Nevada law. For those of you who are listening or wondering why our legal counsel is not here, they have been inundated with bills and they are feverishly working to make sure that they get everything out on time. So we'll send the question to our legal counsel and make sure that they can respond in kind. Okay. Thank you. Any other questions? I don't see any hands.
Madam Chair, I'm sorry, this is Senator Pickard. My raise hand feature isn't working. So if I may.
Please proceed.
Thank you. And it's wonderful having Senator Neal, another attorney, on, because she asked all of my conflicts of laws questions. I just have one left, actually, and it's a practical one. I'm wondering, how does this work in practice when we've got such a broad scope of work here in Nevada, particularly after the last session, where we've added some things that are a little unusual? So say somebody comes to Nevada from Oregon or Washington, and now they're authorized to perform services that they're not performing in their own states. How do we assure Nevadans that they're actually competent to do the broader scope of work? Or do we limit them to whatever their scope is in their states?
Senator, Madam Chair, members of the committee, I'm happy to answer that again. The Physical Therapy Compact Commission has in our...
Mr. Cantwell, please say your name for the record. Yeah.
Oh, it's TJ Cantwell, Physical Therapy Compact Commission Administrator. The answer is the scope of practice where the patient is receiving care is what that physical therapist would have to operate under. And so if you have limitations on certain practices in the state for physical therapy, that individual, whether they came from another state in Oregon that, say allows something like, again, they allow direct access or dry needling, things like that, it would be the responsibility of that physical therapist or physical therapist assistant to know the laws of the state of Nevada in order to follow those laws and abide by them, again, like they would today under a license. And so they would still be required to take a jurisprudence exam, again, to understand what specific laws and requirements are in the state of Nevada, what they can and cannot do, and then be held to those laws as well, and rules and regulations, and could only practice under what the state of Nevada would allow. And therefore, again, it would not be a case where they would still be able to do something they were allowed to do in another state, and it would be under the jurisdiction of the Nevada State Board to regulate that and regulate that individual who's practicing under a compact privilege, again, the same as it would be if they were practicing under a license.
Right, and I appreciate that, Mr. Cantwell. I'm actually asking the inverse, where they come from a state, and you said dry needling, you opened the door, so I'll use that one. But say they're not licensed, they don't have any experience, their state doesn't allow for dry needling, they come here, we do. Are they now allowed to start sticking needles in people even though they may not have practiced in that area? How do we protect Nevadans from that sort of scenario? And I'm not saying anybody actually would, right? I mean, I've benefited from physical therapy. They're great practitioners. I just think that we need some understanding of, if someone comes from a state that doesn't allow a certain procedure and they come to Nevada where we do, they're technically not qualified because they've never been allowed to do this in the past. How do we protect Nevadans from someone who would say, oh, now I can start sticking needles in people, I'm going to do this? How does the system work in that case?
Senator and the members of the committee, again, TJ Cantwell with the Physical Therapy Compact Commission, I would defer to Mr. Harvey with the board. Again, the same process and procedure for ensuring that somebody is qualified to do a certain procedure, or again, would be qualified to do something else, would be again the same process that they would have to apply for if they are getting a license in the state. So whether they have a competent provisional license. So Mr. Harvey would probably be the best to answer how that's handled today.
For the record, Charles Harvey, Executive Director. Senator Pickard, to your point, There is a formal process in place for practitioners to perform the practice of dry needling. That speaks to that specific practice. As far as the other practices are concerned, the board conducts inspections where we go out and we inspect facilities, we inspect each practitioner, and if they are found to be performing a practice that they are not qualified to perform, they would be, notified at that point to discontinue, and a formal investigation would take place at that point. In addition, we have a formal complaint procedure where any member of the public or another licensee can submit a complaint, and that would kick off another investigatory process.
Right, I appreciate that. And so what I'm hearing is that it would be a reactionary response as opposed to a proactive one, and that there's not a system in place to make a comparison of the scope of practice from the originating state as they come into Nevada. And so there's no way to know if this person is qualified coming in. We wait until until a complaint is formed. Is that accurate?
For the record, Charles Harvey. I neglected to mention that before practicing in the state of Nevada, licensees would have to take a jurisprudence exam that includes questions pertaining to our specific practice act, NRS 640 and NAC 640. And that would make them become familiar with our specific statutes and regulations before they are able to perform here in Nevada.
Right, and I guess I'm not as concerned about them knowing the laws, knowing the competencies of the practice. But in any event, thank you, and thank you, Madam Chair.
Thank you. Additional questions, committee members? So I just have a couple. I can't remember who said it. I think it's 2 months. Someone mentioned that the compact would allow PTs coming from somewhere else to be able to practice here in the scope of practice. And I'm alluding now to Senator Pickard's questions. Almost immediately rather than 2 months. Can someone tell me why it would take 2 months for someone who has applied for a license to get it?
Charles Harvey, for the record. The 2-month process is approximately, once they start the application process, it's usually the criminal history background check that takes the duration of that 2 months. Once we receive a complete application that includes the criminal history background check, it takes approximately 2 days to license someone in Nevada.
Okay, thank you. Ms. Kelly, this question is directed to you. I believe in your opening statement, you mentioned 68% of the military who are married, the spouses say that they want to or need to work. Can you speak to the, quote, need to work aspect?
Yes, Kelly May for the record, Kelly May Douglas for the record. Thank you, Madam Chair. So the 68% was the response on a recent survey of service members who indicated that their spouse's ability to obtain or to continue their career affects their decision to stay in the military. 77% was the percentage of spouses that stated that they needed or wanted to work. On that note, just as in the civilian community, more and more military families are deciding that they need to be a dual income. They need 2 incomes in their family to survive. So not saying that the military is an anomaly, it is very much like the civilian community where we've seen this increased need for a dual income situation. So if military spouses are not able to get to work immediately or without undue delay, it really affects their future decision as a family to stay in the military, because they might need to make choices that will facilitate greater financial stability.
So I just want to enter this into the record for those who may not be familiar with military pay, and I know so often people think people in the military are rich, and that's far, far, far from the truth. The 2021 pay chart for someone who is just entering the military, a private, that's E1, no stripes. The annual salary is $20,170.80. For an E2, it goes up to $22,000, and for an E3, which is a private first class, it's got the arrow, as some people say, in the rocker under it. For a sergeant, it's $28,000, and for a staff sergeant, it's $31,000. If you look at officer pay, a second lieutenant, brand new out of West Point or out of ROTC, makes $38,000. A captain would make $51,000, and a major would make $58,000, and that's base pay. So, in every sense of the word, especially if you go back to the enlisted, $20,000 we know is less than $2,000 a month, and someplace like Las Vegas, it's impossible to live off of less than $2,000 a month, because any place that you would find that would be worth you living and putting your family there is going to cost you probably about $2,100 a month, just if it's got 2 or 3 bedrooms. So I just wanted to enter that into the record so it would put some perspective on the reason that Ms. Douglas said need to and want to. I'll also say this, a point of privilege, that we do have another piece of legislation coming up later that will ask our federal delegation to begin the process of developing a national 401k or retirement plan for our military spouses. One of the things that happens is because people are married to a military service member, if they have an occupation or they're professional, they never get a chance to get vested. And so for their support of the military member in their 20-year or more career, the military member has a pension, the spouse does not. And I just think that's wrong. We ought to be taking care of our service personnel much better than that. I won't go on. I think all of you all know how I feel about military and veterans. So I think our vice chair has another question. Yes, ma'am. Proceed.
Thank you, Madam Chair. I appreciate the indulgence. I thought there were, I was trying to hold back on my questions, so, since everybody's so quiet because it's so early. But I
think Senator Pickard's spirit has jumped on you, but proceed.
Yeah, I don't know about that. Okay, but in section 6, I just have one more question related to it's line 39, and it is 6 sub B. So I just want a clarification here where it says that member states shall share any investigative, litigation, or compliance materials. So I know what was said before, Nevada law, but sometimes, you're real specific in certain places, but very broad when it comes to licensees. So this includes privilege materials as well.
For the record, TJ Cantwell, Madam Chair, members of the committee, the answer to that is it would be restricted to what is allowed by the states. So we actually, in further rules and to further to your point, the rules do clarify, and they're publicly available. The Compact Commission rules do clarify on that point that it is specific to the investigatory information depending on state law. So state by state, we recognize that there are different laws that govern what can and cannot be shared for investigatory information. And so we specify in our rules that are adopted by the full commission, and therefore all the states must abide by them, is that it is required to only share the information that is allowed by state law. So again, some states have more flexible laws and others have more restrictive ones. And so whatever that state is allowed to share by under their state law is what is required to be shared.
Okay, thank you for that. And then just one final question, Chair, it's a last section of the bill in Article 10. This is on, and I'm going to tie these questions together. So, because I was reading the qualified immunity for the commission on page 12, and then when I was reading Article 10, if you go to Article 10, page 17, lines 14 through 18, it is where they're talking about that a state is terminated and responsible for all of the assessments, obligations, and liabilities through the effective date of the termination. So when I read that, I understand that if you get kicked out after termination, then you are liable for everything. But this says through. So basically, you're going to strip all of the immunity up to the date of termination, because that's how that reads. And I don't know if that is how it's supposed to read, because when I read through the termination, that is all the way. That's not after.
Madam Chair, members of the committee, TJ Cantwell, that may be one that I'll have to refer back to our legal counsel. Again, I believe that those two separate sections are referring to two different things. Again, qualified immunity specifically related to the officers and directors of the compact, and again, very similar to common language related to qualified immunity for members of any state board or organization. But when it refers to Article 10, again, your reading of the through, again, is a new question I think we haven't received before. But I would separate those two, I think, and from way I understand it, but that the qualified immunity again is not related to that. It's referring to the fact that the state that would be potentially terminated, you have to pass a law. The law would have to be repealed again once you join the compact in order to terminate your standing in the compact. So I believe if you were terminated by the compact itself, then it's referring to the actual date of which that termination would take place, depending on when the judgment was taken. But I would like to note that there's not been any action that's been taken. We're not the first compact. Nursing compact's been around for more than 20 years, and I believe there's only been one legal action taken in the last 20 years in their compact, and that resulted and was resolved in arbitration without a state having to be terminated by the compact. Obviously, that's not the goal of any commission, is to maintain and keep all the states in there to be able to have access for as many consumers as possible. But again, if you allow me to refer that to our legal counsel, I'm happy to get an answer to you as well.
Thank you, Madam Chair.
Sure. I don't see any other hands raised. It's not any more questions by committee members. Senator Hardy, you were looking. Did you have a question? No?
Not relating to this. Thank you.
Okay. So just before I close the hearing, I just want to put something else on the record as to why there is a need to take care of our military spouses. It's not just them following their service member from post to post, or base to base, state to state, country to country. It's also the fact that for many of them, especially within the last 13 years, since we've been involved in a minimum of two acknowledged combat situations, they are there for their spouse that is deployed to Iraq, Afghanistan, or wherever. And many times when the deployment happens, it is the spouse who is left behind to take care of the family, etc. Some of them, if the spouse is going to be gone for longer than 9 months or 18 months, some of them elect to move back home where they have support from family members, much like civilians seek places of refuge for their family members. So I'm just trying to put this on the record. I think we only have maybe 5 veterans in the legislature, and that includes Senate and Assembly. And sometimes it's better if you can put this all into context, the way that the military spouse is experiencing it. Sometimes it lends itself to greater understanding. So with that and no additional questions, then I will close the hearing on Senate Bill 100. Thank you, Senator Severs-Gansert. Appreciate it.
Thank you, Madam Chair.
Thank you. And we'll make sure that we get the answer to that question. Vice Chair Neal, if you'll write your question down, we'll make sure that we get it to Mr. King so we can get an answer and make sure that that is a part of the record. Even if we do it at the work session, I just want to make sure that we've answered that question to your satisfaction and to anyone else who may have that same question. So,
Chairman?
Yes, ma'am.
We're going for support, right?
Yeah. First is support. Mm-hmm. And so I will now. Oh, I said close the hearing. I'm sorry. Open the hearing back up. So we'll now go for support. The time frame for support is 30 minutes. And I've noticed that 2 minutes may not be long enough, so we'll go 3 minutes. And if everyone does 3 minutes or just does ditto, we can get at least 10 people's comments on the record. So thank you, Vice Chair. I'm ahead of myself. So broadcast, please open the lines for support for Senate Bill 100.
Thank you, Chair. To testify in support of Senate Bill 100, please press *9 now to take your place in the queue. Caller with the last 3 digits of 777, please slowly state and spell your name for the record. You have 3 minutes and may begin.
For the record, my name is Dr. R.J. Williams. I am the Nevada Physical Therapy Association president, and I want to thank you all today for your consideration of the bill SB 100. And I just want to stand up in support for this bill that the board is putting forward and just voice that on behalf of the Nevada Association. As Dr. Nash mentioned in her testimony earlier today, there's a growing concern of access for our state for physical therapy. As she mentioned, we are the lowest ranked state in the nation per capita of therapists to the population. This would do a great service at helping improve that. As Nevada continues to grow, and we've seen things like professional sports teams now in Las Vegas join, the attention and desire for more people to come to the state is only going to continue to increase. And so by being able to serve our metro areas as well as the rural areas, as she mentioned, where our neighboring states may be able to quickly gain access to provide that care would be absolutely essential to keeping up with the pace and meeting the demand and giving people a safe and healthy alternative to manage pain and other disabilities, as well as the mentioned military services, something we also greatly support, knowing that we have people that come to our state for employment through the service, and getting them quickly able to practice is something that we fully support. So on behalf of myself and the therapists as part of the Nevada Association, we stand in support today. Thank you.
Chair, there are no more callers in support at this time.
Thank you. Then I will please open the lines for those who are in opposition. Same time frame, 30 minutes and 3 minutes per.
Thank you, Chair. To testify in opposition of Senate Bill 100, please press star 9 now to take your place in the queue.
Nobody.
Chair, you have no callers in opposition at this time.
Thank you. So those who are testifying neutral, same time frame, 30 minutes, 3 per.
Thank you, Chair. To testify in the neutral position of Senate Bill 100, please press star 9 now to take your place in the queue. Madam Chair, there are no callers in neutral at this time.
Okay, thank you. And so with that, Senator Siebers-Gansert, do you have any closing remarks? I should have asked that the last time too.
Thank you. For the record, Senator Heidi Siebers-Gansert. I want to thank the chair and the committee members for listening to Senate Bill 100. And I think it really would help veterans and their spouses, their families, as well as a lot of other folks potentially, so we can have greater access to care. So thank you for your consideration.
Thank you. Senator Hardy, I think your microphone is unmuted or was unmuted a couple of times. Do you have a question or anything to say on record? I just want to make sure.
Yes, I love this concept. I think it makes sense and I fully support it. And I think it's a model that we can look at for other people. And I'm thrilled that we have such a wide support for my veterans and my military people. And I can't say enough, obviously. So thank you, Madam Chair, for allowing me to speak.
Thank you, sir. Any other committee members want to have some closing remarks? Okay, so with that, I will close the hearing for the second time, and I think it's the final time. So thank you, Senator Siebers-Gansert, and everyone who participated in providing us this information. Certainly appreciate it, and we will take all of this under advisement and trying to make sure if there are no real hiccups that we process these bills as soon as possible, because it's going to get really hectic real soon. And so for those where there's no opposition, we want to try to get that done as soon as possible. So thank you all. I appreciate it. So now,
Madam Chair?
Yes, Senator Settlemyre.
In that respect, if you'd entertain a motion, I'd gladly give it.
Let's wait until Monday at least, okay? I want to do that to make sure that there's nothing else that comes up in terms of question, as well as want to make sure we get the answer from our legal counsel for Vice Chair Neal's question before we do that, okay? But I appreciate the support and the motion, but I want to wait at least until Monday, okay? Right,
okay,
thank
sure.
you. Okay, thank you. So now we will go to public comment. If there's anyone on the phone lines that wants to comment, broadcast, will you open up the phone lines at this time? Thank you.
Thank you, Chair. To participate in public comment, please press star 9 to take your place in the queue. Madam Chair, the public line is open and working. There are no callers for public comment at this time.
So I appreciate everyone's participation. All questions usually provide a lot more insight to the bills. I know I learned a lot from that too. So With that, we will close this edition of the Senate Committee on Commerce and Labor, and we will be right back here on Monday morning. Thank you all. Have a great weekend.